Hello, and welcome once again to Lehto's Law. I'm Steve Lehto, attorney at law in the state of Michigan, where I've been practicing law now for 24 years in the fields of consumer protection and lemon law. I'm a frequent writer for Jalopnik's subblog, The Garage, and from time to time I contribute to Opposite Lock as well. People often call my office with questions involving cars and the law because I specialize in lemon law, but not all questions involve lemon law. And sometimes people call me and they say, hey Steve, my car got damaged while it was in someone else's possession. What can I do? So here's how you strike back when the shop damages your car. The most typical example I can think of is someone takes your car out for a joyride. You drop your car off for service. Heaven forbid you drop off a nice car at a dealership for service, and one of the techs decides to take your car out for a joyride. Simply type the word joyride into YouTube's search engine. You'll find all kinds of examples of people doing this with cars they shouldn't be doing it with, and they often get in trouble for it, and they often damage the car in the process. Another thing that can happen, it's happened to clients of mine. Client drops off a car at a dealership, they have service done on it, and they have it for a couple days, and a service person calls up the client and says, hey, I got a problem. Someone broke into your car last night and stole your stereo. You need to file an insurance claim. And that's not the case, and I'll explain that in a second. Then, of course, we just simply have a situation where a bad mechanic damages a car while trying to fix it. An oil change is the best example of that. And people often have these problems. They call my office, they say, what do I do about it? And I often say, well, this is not a lemon law problem per se, but there's a law right on point. And in Michigan, the law is called the Garage Keeper Liability Act. But most states have got laws similar to this. And now let me explain how this works. In Michigan, and I'll give you the statute in a second. In Michigan, the law is called the Garage Keeper Liability Act. The statute's MCL 256.541. If you look that up on the internet, you can find it listed in a bunch of different places. Michigan's laws are all online. People often tell me, they say, well, Steve, the law says such and such, and I often say, show me where it says that. And that's because the law is written down and you can point to it. So if the law exists, it's there. It's in the Michigan compiled laws, or the MCLs. So MCL 256.541 is the Garage Keeper Liability Act, and it's very simple. What it says is, and I'm going to read this to you, and I don't often read big blocks of text during my podcast, but I got to do this so you get the language. Whenever any damage shall be done to any motor vehicle while in the possession or under care, custody, or control of the owner, his agent or servant, or the keeper of any public garage or other establishment where such vehicle shall have been accepted for hire or gain, proof of such damage shall be prima facie evidence that such damage was a result of the negligent act of such owner or keeper of the place where such vehicle was stored. In plain English, if you bring your car someplace and they have it in their possession and they're making a profit off of you, it becomes their problem if things happen to your car. Doesn't matter who did them, it's their problem. The Garage Keeper Liability Act is designed, in essence, to put the burden on the owner of the facility where you take your car to protect your car against bad things. And this law shifts the burden of proof onto them. It basically says they're negligent unless they can prove otherwise. And that changing of the burden of proof is huge because it's often a difficult thing for them to get out from under. So let's say an employee takes the car for a joyride and damages the car in the process. All you got to do is prove that the joyride took place. You don't have to prove that the owner of the shop was negligent in any way because it's presumed he was negligent. He shouldn't hire employees who take vehicles for joyrides, or he should have some kind of systems in place to keep employees from going in joyrides of cars. They could do that by keeping the keys someplace handy. They could do that by having surveillance in the place. There's all kinds of things they could do. But despite that, of course, go on the internet, type into YouTube's search engine, joyriding mechanic, and you'll find all kinds of examples of mechanics who take vehicles for joyrides. Some of them film it themselves and post it, and some of it gets filmed by hidden cameras. It's always funny, except when it happens to you in your car. So a mechanic taking your vehicle for joyride is a problem. All you have to do is prove that the joyride took place, and you will be able to recover damages from the garage keeper who took your car in and failed to keep that from happening. The second most common thing that actually happens to vehicles that get brought in for service is that someone breaks into the vehicle. And I've had clients call me, they say, Steve, I brought my vehicle in for work, that sat there overnight, and the next morning they call me and say, someone broke into my car and stole my stereo, or they stole things out of the trunk, or they stole parts off the car. I mean, I've actually had someone tell me that they had high-performance parts removed from their car, which would take hours to do, obviously done by an employee of the shop. And the shop says, well, we don't know who did it, so you file a claim with your insurance company. The last thing you need to do is file a claim with your insurance company. This is why garage keepers and mechanics facilities and things like that. This is why they have insurance. It's for things like this, because every business might have this problem, so they buy insurance to cover themselves for it. So you don't file a claim with your insurance company, you file a claim with their insurance company, in essence. So the way the law is written, it shifts the burden of proof onto them. Now, to understand what negligence is, and I, again, have to give you the thumbnail sketch. Negligence, generally speaking, is when someone owes someone else a duty, and they breach that duty, and it harms the other party. Best example is auto negligence. So I'm driving my car. I owe you a duty to drive my car safely. So if I'm driving my car in a dangerous manner and I harm you in the process, you can sue me for auto negligence. I've driven my vehicle negligently, I've harmed you, you can sue me for that. So a garage keeper owes a duty under this law, owes a duty to safeguard your car from bad things happening to it. And the law says that you don't have to prove that they were negligent in the process. The negligence is presumed to have happened. Otherwise, these things shouldn't have happened to your car. So if your car gets taken for a joyride, like Ferris Bueller's Day Off, and you can simply prove that the joyride took place, you don't need to prove that the shopkeeper was negligent to allow it to happen. Likewise, someone broke into your car and stole stuff out of it while it was in their possession. That's on them, not on you. I've written about this before, and I may have mentioned this story before in a podcast. I once brought a vehicle in for service at a dealership near my house, and while I was talking to the write-up tech, someone else walked up behind me and moved my car, and I hadn't realized they had done that, but the keys were still in it. And when I went back to my car, some things were missing, including some cash, which had been in the ashtray. Now, you might say, well, Steve, come on, cash in the ashtray. Well, I parked the car there, and I hadn't anticipated the car being moved without my permission. So I went back to the service manager, and I said, hey, someone stole a $20 bill out of my ashtray. And the guy said, how are you going to prove that? And I pulled up my business card and I said, I'm an attorney. I don't need to prove anything, okay? But if you want to see how this goes down, feel free. And the guy reached in his wallet and he pulled out a $20 bill and gave it to me. And that's the way it should have gone, because it was his fault, not mine, that someone who works for him stole money out of my car. Things like that happen, unfortunately, all the time. The other problem, of course, and this is not as hard to prove, but the bad oil change. And there's been a lot of articles recently about this on Jalopnik and elsewhere, about the crazy things that oil change shops do during oil changes, especially when they don't know what they're doing. So a typical vehicle comes in, they pop the drain plug, they pop the oil filter off, they slap on a new filter, they slap the drain plug back in, hopefully, and stick the oil back in the car and you drive on down the road. But if in the process they damage your car or they fail to do the oil change properly, the damage that results from that is presumed to have been caused by the negligence of the people who were working on your car. And you don't need to prove they were negligent. You just need to prove that something bad happened to your car while it was under their control. And that, of course, is the thing, because the law is written very broadly. It says under the care, custody, or control of the owner, agent, servant, or keeper of the public garage or other establishment. This is one of the funnier things that happens is this often pops up with a question regarding parking structures or parking lots. You pull into a parking structure and you hand them the $5 or $10, whatever it costs to park on your parking deck, and they hand you a ticket stub and they say, here you go, and that's a receipt, and you go park your car. And as you drive into the lot, you see a huge sign on the wall that says, we are not responsible for anything done to your car while it's in our possession. And if you flip the ticket stub over, it often says in the back, this is a contract. We're not responsible for anything that happens to your car while it's in our custody or control. That's all on you. And the amazing thing about this, of course, is the sign on the wall is meaningless. They put the sign there because they own the wall. They could put a sign on the wall that says 2 + 2 = 5. Wouldn't make it true. Okay? So they put a sign on the wall that says we're not responsible or liable for anything that happens to your car while it's in our possession. They're doing it specifically to discourage legitimate and valid lawsuits. Because what happens is somebody comes back and says, hey, dude, while my car was in your lot, somebody broke into it and stole the stereo. And they point to the sign on the wall and they say, well, that's not on us, that's on you. See, there's a sign on the wall. And they've done studies, and many people will believe a sign on the wall over common sense or the law. Likewise, when they hand you a piece of paper that's got tiny print on the back of it that you think is a receipt and it says this is a binding contract, it's not a binding contract. Otherwise, they could print on the back of the receipt, this is a ticket to the latest Star Wars movie, take it in and go watch the movie. And obviously you couldn't do that because that's not what it is. So simply calling it something doesn't make it something, okay? So when they say this is a binding contract, it's not. So yeah, I hope that you've never fallen for that. I've heard anecdotally from people who have. They said, well, Steve, while my car was in the lot, it got damaged. I went and spoke to the guy at the front. And by the way, the guy at the front, strangely enough, is often the owner of the lot. I don't know why that is. A lot of parking lot owners man their own booth at the front of the lot. When I went to law school, there's a guy from Sri Lanka. And I got to know the guy very well because I parked my car in his lot for 2 years and paid a monthly fee to park there. And I got to know all about Sri Lanka. And what was amazing about it was this guy owned the lot. And I never had the nerve to ask him where he got the money to buy the lot. But he bought what must have been a very expensive lot in Los Angeles. And he made a boatload of money by renting out spaces on a monthly basis to law students at Southwestern University School of Law, Los Angeles on Wilshire Boulevard near Bullocks. Look it up. It's true. It's a real place. I went there for a couple of years. And this guy owned the lot. And on the back of his ticket, it said, this ticket is a binding contract. And on the fence surrounding his lot, it said, we are not responsible for anything that happens to your car while it's in our possession. And I remember thinking to myself, I'd ask him about that, but I know darn well when he bought the lot, the language is already painted there. And he bought the tickets from some printer who just sells pre-printed tickets to parking lot attendants or parking lot owners. Says, here, use this. It'll dissuade lawsuits, okay? But it's another story altogether. So what the Garage Keeper Liability Act does, and by the way, there's almost every state's got one of these. So check in your state for the same thing. Go into Google and type in Garage Keeper Liability Act. And remember, it's different than garage liability. It's Garage Keeper Liability. And type in Garage Keeper Liability in the name of your state into the search engine. Hit go, and you'll find the law. Almost every state's got one. It's usually titled something similar to that. It's a lot of common law language there. So find the statute in your state and find out what it says. Because what it basically does, like I said, is it shifts the burden of proof so that it becomes negligence on their part if bad things happen to your car while it's in their possession. Now, this does mean that if they won't cooperate with you, you still may have to sue them. And anybody who's gone to the trouble of putting up a sign on a wall that says we're not liable and also has put printed language in the back of a ticket that says this is a binding contract, even though it's not, will probably not pay a claim simply because you file it. So what you're going to need to do if your vehicle gets damaged while in their possession, you probably will have to sue them. Now, here's the thing to keep in mind. I've dealt with a lot of businesses before where if you threaten to sue them, they don't do anything. Apparently, they get threatened to sue, with suits a lot. What's more likely to get a result is when you file the lawsuit itself, they'll often say, fine, we'll pay you. Sometimes it's because insurance companies' coverage kicks in on actual litigation, and sometimes it's simply because they know they can weed out 9 out of 10 claims by ignoring the threats. A lot of people call my office and say, Steve, will you write a threatening letter for me? And I say, no, I won't. In my mind, if I'm going to threaten to sue you, I should only threaten to sue you if you actually plan on suing you. And in that case, why not just cut out the middleman and sue somebody? So I almost never write threatening letters to anybody because in my mind, they're worthless. And even on letterhead, when somebody sees a letter from an attorney that says, I'm going to sue you, people look at that and say, well, if the guy's an attorney, why isn't he suing me? It's like a doctor threatening to operate. I mean, just go ahead and operate already, okay? So you will have to sue them most likely to get them to respond. And the main thing, like I said, though, is the burden of proof is shifted onto them. The primary thing you simply have to prove is the vehicle is in their possession and it got damaged while in their possession. Then it becomes the burden on them to somehow prove they weren't negligent. And the law presumes it's in their possession, it's in their care, it's in their custody, it's in their control. They're supposed to be safeguarding your stuff, okay? And, obviously, a parking deck with 1,000 cars in it and a ton of traffic, they might be able to convince a judge that, hey, we weren't negligent and something happened that was just so bizarre and out of our control that we couldn't imagine it ever happening. But a shop that takes your vehicle in for service and it gets damaged while on the lot in their possession, they're going to have a really hard time defending that. And what's amazing is the number of times I've spoken to people or corresponded with people from Jalopnik who said that their vehicles were damaged while in the possession of car dealerships while inside fenced lots that were topped with razor wire, okay? Doesn't take a rocket scientist to figure out who's doing the damage to a car that's inside a locked and gated yard topped with razor wire, and the only people allowed inside there are employees of the parking lot. So, employees of the dealership. So you can figure that out. So we know who's liable. You got to go ahead and sue them. Now, the one slight problem with this statute is it does not allow for attorney fees. A lot of statutes out there will actually say if you prevail, you get your damages and your attorney fees. Garage keeper liability simply shifts the burden of proof to the other side. So what will happen in a case like this is you will file the lawsuit, and if you win, and you get what you win. If you have to pay an attorney to do this, it might not be worth your while unless there's a lot of damage done to your car. But the cool thing about this is one that I would urge you to take to small claims court, okay? So your vehicle gets, damaged at the dealership and someone breaks in and crowbars out your stereo or steals your wheels off of your car, things of that nature. Go ahead and sue the dealership in small claims court. And when you go into court, you literally walk in with a photograph of what your car looked like before, photograph what it looked like afterwards, receipts for what it's going to cost to replace all the stuff that was done to your car, and then a copy of the Garage Keeper Liability Act. I had a discussion recently with somebody on the phone about this because they said, well, why do I need to explain to the judge what the law is? There's not a judge on earth that knows all the laws, okay? A judge who is in district court in Michigan is going to know the drunk driving laws very well, the landlord-tenant laws very, very well, and breach of contract and things that pop up all the time in their courts. But the Garage Keeper Liability Act doesn't pop up that often in their courts, so it's not like they're going to have this in front of them all the time. They may have heard of this statute, but with them dealing with it, I highly doubt it. So bring a copy of the statute with you, and when you say, Your Honor, Garage Keeper Liability Act MCL 256.541, you'll notice the judge will glance down and write something down. And what they're writing down is the citation you just gave them, MCL 256.541, and the judge will then look that up. A lot of judges have got computers in their desks. They actually have the internet up there nowadays, and they can look this stuff up. And so when they look that up, they're going to confirm that that's what the statute says. They say, oh, wow, learn something new every day. And I've had many judges tell me, not just on this statute, but the Lemon Law, the UCC even, that they learned something by having a case of mine in front of them, because the car cases I do, although common in my office, are extremely uncommon in the Michigan courts. So I've actually had a judge tell me, this is my first Lemon Law case, this is my first UCC case in a while, or this is my first, you name it. And any one of these wacky cases, I've actually had it where judges say, I've heard of this law, I've never really looked at it before. So again, if your vehicle gets damaged while in the possession of somebody who's got your car and they're making money off of you, again, you can go after them under the Garage Keeper Liability Act, and that is how you strike back when the shop damages your car. Questions or comments, always contact me at my website, lehtoslaw.com, LEHTOSLAW.com. I'm on Twitter at Steve Lehto, at STEVELEHTO. And this show is on iTunes, Stitcher, SoundCloud, and YouTube. Thanks for listening and watching. Bye-bye.